The HIR Act explained. New bill targets foreign workers and green card hopefuls. Quiet shift with big consequences. If you've been following U.S. immigration lately, you've probably felt the shift. A slow, deliberate tightening in how America defines who gets to stay, who works, and who builds a future here. That shift just took another step forward, with a new proposal now being debated in Congress, the HIR Act. It may sound technical, but its impact could be massive. This law aims to reshape the very foundation of how foreign workers are hired, sponsored, and retained in the United States. And for thousands of H1B, L1, and green card applicants, this could be a defining moment. What the HIR Act really means. The HIR Act, short for Halting International Relocation of Employment Act, was introduced in September 2025. On paper, it's being marketed as an economic reform, a way to stop companies from sending work overseas or outsourcing roles that could go to American workers. But beneath that language lies a far more serious story about how U.S. immigration priorities are evolving. This is not just about economics. It's about control, compliance, and the cost of foreign labor. The core, what the bill proposes. Under the HIR Act, U.S. companies would face a 25% excise tax on payments made to foreign workers or offshore contractors, if those services are used for U.S. work. It also removes the ability for companies to claim those payments as tax deductions. Supporters say it's about keeping American jobs in America. But for immigrants, the message is different. Your sponsorship might soon come with a heavier price tag. When the cost of employing foreign talent rises, employers change behavior. They may hesitate to file new H1B petitions, delay green card sponsorships, or shift toward contract-based work. That's where the ripple begins. How? It connects to a bigger agenda. The timing of this bill is not random. It aligns closely with the Trump administration's broader immigration philosophy, one that prioritizes domestic labor and stricter screening. Over the past 2 years, USCIS has been given broader discretion. Officers are applying deeper background checks, and approvals are now closely tied to labor market data. And just recently, the Department of Homeland Security reaffirmed that immigration programs must serve the national workforce first. That phrase now shapes how petitions are reviewed, not just for employment visas, but even for family-based categories. So, when a bill like the HIR Act appears, it doesn't just come from nowhere. It reinforces a policy direction, one focused on selective immigration where every step is judged by how it benefits the U.S. economy. Impact on H1B and L1 workers. If you're currently on an H1B or L1 visa, this bill could make your employer think twice. The 25% tax might not apply directly to you, but it could affect how your company budgets for foreign labor. Some firms might reduce international hiring altogether. Others might avoid extensions or new filings due to increased compliance costs. That means fewer opportunities and potentially longer gaps between petitions. Expect stricter documentation checks, tougher renewal scrutiny, and even shifts toward short-term assignments instead of full-time sponsorships. In simple terms, the hiring pipeline for foreign professionals could slow down significantly. Effects on green card applicants. For employment-based green card seekers, the ripple continues. If employers scale back sponsorships, demand patterns shift, and so does the flow of visa numbers. That change could create further stagnation in the visa bulletin, especially in high-demand categories like EB2 and EB3. Those already waiting abroad may face even longer timelines as companies pull back on filing new petitions. Even applicants inside the U.S. could see fewer labor certifications or longer delays before perm approvals. And while this law doesn't directly alter USCIS processes, it indirectly reshapes how many people even get to apply. Effect on lawful permanent residents. If you already hold a green card, you might think you're safe, but the ripple still touches you. Every shift in labor-linked immigration rules impacts renewals, naturalization, and background checks. When Washington connects immigration to domestic job markets, every future filing becomes less predictable. USCIS is already strengthening its good moral character and public charge reviews, taking a closer look at tax compliance and employment history. So even for those on the path to citizenship, the HIR Act reflects a system becoming tougher, slower, and more risk-averse. What it says about America's immigration moment. For decades, the U.S. economy relied on foreign-born talent in tech, engineering, healthcare, and research. That's still true. But the political tone has changed. The narrative is no longer about innovation and growth. It's about competition and replacement. The Trump administration has reframed immigration as a question of who benefits, the American worker or the global talent pool. And that debate is now being codified into legislation. The HIR Act is not just an economic law, it's a signal of where immigration policy is heading next. The divide, supporters versus opponents. Supporters of the bill argue it's long overdue. They claim it protects local workers and reduces dependency on global outsourcing. They believe U.S. tech and service sectors need to reinvest in domestic talent. But critics, including business coalitions and immigrant advocacy groups, see it differently. They warn that this could cripple innovation, hurt startups, and push global talent to friendlier countries like Canada, the UK, or Australia. It's a tug-of-war between political optics and economic reality, and immigrants are caught right in the middle. A system under stress. To make things more uncertain, this debate arrives alongside other major immigration changes. The end of automatic work permit extensions. A visa bulletin slowdowns through late 2025. New vetting standards for citizenship and background checks. Together, they paint a picture of a system under maximum pressure, one that rewards early preparation and punishes delay. Immigrants now face a system that's not just slower, but more unpredictable than ever. What you should do now. Here's the takeaway. This is not the time to wait and watch. It's the time to plan ahead. Talk to your employer about how the HIR Act could affect sponsorship or renewals. Keep your immigration documents updated and ready for verification. File early for EAD renewals, H1B extensions, or green card adjustments. Monitor USCIS announcements closely. If this law passes, those who stay informed will adapt fastest. Those who delay could find themselves stuck between expired work permits and shifting compliance rules. In today's environment, being informed isn't optional, it's survival. The bigger picture. The HIR Act might still be just a proposal, but its message is already clear. It's not one big reform, it's part of a series of small technical shifts that together redefine U.S. immigration. Each one adds a new cost, a new form, or a new rule that changes how long you wait and how much you pay. This is how U.S. immigration is being reshaped, not overnight, but piece by piece. Whether the HIR Act passes or stalls, the direction is set. The focus is on scrutiny, selectivity, and self-reliance. The future belongs to those who can navigate that complexity with patience and preparation. Stay ready, stay informed. That's all for this update. If you found this breakdown useful, make sure you're subscribed because the landscape is changing fast and you'll need every update to stay ahead. If you liked this video, don't forget to hit like, subscribe, and turn on the bell icon for future updates. Thanks for watching. See you in the next video.